Hi everyone. So we are going to start with the revision classes for CA Foundation with regard to the Contract Act. More emphasis on the provisions of Contract Act we are going to give. In the first lecture, it will be a small lecture which will be taking up a concept called as consideration concept under the Contract Act. What is the concept? Consideration concept under the Contract Act. So first let us understand what is this concept of consideration, and after that we can understand the remaining parts inside it. Okay, so listen carefully to the point. Whenever we call a contract, contract is a agreement enforceable by law. When any agreement is enforceable by law, we call that as a contract. Agreement will be formed because of promises. One person makes a promise that he will supply the goods. Another person will make a promise that he will pay something in return. That pay something in return only we call as consideration here. What is this concept of consideration? Importance of consideration in a contract. What happens if consideration is not there? Exceptions to the rule. Everything we are going to discuss in this session on a revision basis. Very quickly we will complete the concept. I don't waste your time. Okay, let's start. So let us understand what are all the concepts that are applied for examinations. First let us see in that point. Consideration is an essential element of a valid contract, without which no single promise is enforceable. Exactly what I have written here. Okay, because agreement is a set of promise. One person makes a promise that I will supply the goods. Another person will make a promise that I will pay the consideration. Promise will be unfulfilled if consideration is not paid properly. Means what? Two promises makes an agreement. One promise is to perform the contract. Another promise is to pay consideration for that. Okay. So how beautifully Contract Act is designed. Promise number one, performance. Promise number two, paying consideration for that. All performance related concepts are covered by a separate chapter in Contract Act called as performance of contract. All consideration related payments are covered in this chapter consideration. If you do not perform this well, it results in breach of contract. There is a separate chapter covering that, and we have already completed it, but still in the revision sessions I will cover. Okay, that's a performance. If you don't have a proper consideration, what happens we are going to see in this particular lecture. Okay, so consideration is a essential element of a valid contract, without which no single promise will be enforceable. Means what? In order to make a promise enforceable at law, two things has to be satisfied: performance of contract, consideration. In this chapter, emphasis will be on the consideration side. Next chapter, performance emphasis will be there. Okay, consideration is also called as quid pro quo, means something in return. Okay, something in return. Listen, I didn't say exact thing in return. I said something in return. Sir, I didn't understand. Okay, I will explain in this way. Okay, see here. You sold me this iPhone. I should pay some consideration to this. It need not be exactly the real price of that phone, but some consideration must be there. I said something in return. I didn't tell something monetary in return. It may be monetary, it may be non-monetary. It may be equal to the particular product, it may be more than that, it may be less than that, but some consideration must be there. Something in return you should have. That may be in the form of money, that may be not may be in the form of money. It may be monetary consideration, it may be non-monetary consideration, but consideration is important. Monetary or non-monetary is not important. Okay, that's very, very important thing. You give this in consideration, I will give this. Enough. This is also a promise. This is also a valid promise. This is also valid enforceability. But the point is, there should be some kind of consideration with respect to the contract. No consideration, no contract. Okay. So, let us understand. Having a double aspect of a benefit to the promisor and a detriment to the promisee, it has to be really understood in the sense of some detriment as envisaged by the English law. Meaning of that we will see when we are reading what is consideration. Okay. Main element is, it is one of the essential element of a valid contract, without which no single promise will be enforceable. When the promise is not enforceable, agreement will not be there. When agreement is not enforceable, it is not a contract. So no consideration, no contract. So let's see what is consideration. Consideration is the price agreed to be paid by the promisee for the obligation of the promisor. Two persons will be there. Okay, one person will be called as promisor, promisee. Promisor promises, I will do this for you. In consideration, promisee will tell, I will pay this for you. Now we have to see this chapter from this person point of view, promisee. Okay, so price agreed to be paid by the promisee for the obligation of promisor. The word consideration was described in very popular English case law, Misa versus Curie, as follows. A valuable consideration in sense of law may consist of either some right, interest or profit or a benefit accruing to one party, or forbearance or detriment or loss or responsibility given, suffered or undertaken by the other person being a promisee. So what is the meaning? Let us try to understand this. See there. A valuable consideration in the sense of law means, when it comes to law, the term consideration will have the following aspects. It may be a right. Consideration need not be always monetary. It can also be, okay, it can also be a right. A right given to you to use something may be a consideration for the work done. Okay, examples I will give you. Okay, see here. A company said like this: all the employees of a company who work for 2 years in our company, we will give them shares of our company. I repeat, company said to their employees, whoever work in our company for 2 years, after completion of your 2 year service, in consideration, we will give you 100 shares of our company free of cost to you. Now answer, what company has given? A right in the share capital of the company. That's all. Share is also a consideration. Your promise to stay for 2 years, promisee is giving shares in return. A right in the shares of the company. It's a right. A beautiful example. Interest or a profit or any benefit, okay, accruing to one party, or forbearance or detriment or loss or responsibility given, suffered or undertaken by the other person. That means, simply, sir, what is this forbearance? Forbearance means tolerating a particular task is called as a forbearance. This particular sentence, meaning we can understand in the further parts of this chapter. Mainly we need to understand the first part. Valuable consideration may be in the form of giving the rights, may be in the form of paying the interest, may be in the form of paying the profit, or in the form of giving some benefit to one party, okay, accruing to one party. Who is that one party? Promisor. Okay, promisor will be paid consideration. Simply try to understand. Company said to the employees, okay, company said to the employees, if you stay in our company for 2 years, we will give you shares in return. Here, one person is promising to stay for 2 years. Employees are the promisor. They are promising that we will stay for 2 years. In consideration, promisee must pay something to them. Okay, compensation has to be paid for their stay of 2 years. That compensation only we call as a detriment. Okay, insurance companies will be there. For a loss caused to you, they will pay the insurance policy amount. We call them as a loss. We call them as a loss. Okay, next one. Let us see the definition given under the Contract Act. Section 2D defines consideration as follows. When, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such an act or abstinence or promise is called as a consideration for the promise. Sir, what is this? I didn't understand. Sir, let us read once again. When, at the desire of the promisor, when at the desire of the promisor, promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or abstain from doing something, such an act or abstinence or a promise is called as a consideration for the promise. Sir, none of the points are understandable. Sir, what is this confusing definition? Okay, I will explain in a simple way. Let's understand. See here. When at the desire of the promisor, when at the desire of the promisor, okay, the promisee or any other person has done. If you see the language, has done, abstained from doing, this relates to the past. Does or abstains from doing, this is present. Okay, promises to do or abstains or promise to abstain from doing something, this relates to future. You can pay consideration for the act already done in the past, or for the acts that are going on, or acts to be done in the future. Past, if you pay now, it's a credit transaction. If you are paying now, cash transaction. If you are paying in advance, it's an advance payment. Consideration can be anything. That's why I use the word has done or abstain from doing. Abstained, it's a past tense. Does or abstains from doing, it's abstains, it's a present continuous statement. Promises to do, not yet done, promises to do, that means he will do in future. So consideration can be paid for three things: for a future act, for the past act, or for a future act, or for a present act, or past, present, future. That's what Institute had beautifully said here, but students are not reading. That's all. We are reading consideration may be past, present, future. Consideration can be past, present, future. But we don't understand what is the meaning of that. That means you can pay consideration for a past act already done, or for a present act which is going on, or for a future act which is yet to be done. Okay. When at the desire of the promisor. Sir, what is this? Desire of the promisor. Let me explain. Sir, you are a person. You are selling the goods. I am purchasing the goods. Okay. Consideration will be decided by buyer. Consideration will be decided by seller. For example, you promised me that you will sell the goods. I promise that I will pay you consideration. Now, promisee will be paying you consideration. Promisor has to sell the goods. Okay. Now, you as a promisor will decide consideration. Promisee will decide consideration. Payer will be decide consideration. Main person who is giving the act will decide consideration. Promisor will decide. Therefore, how much should be the consideration will be at the want of the buyer. Sorry, seller. Technically, we call him as a promisor. Therefore, where at the desire of the promisor, that means how much to pay will be at the desire of the promisor. Promisor has to decide that. Okay. Okay. Where at the desire of the promisor, promisee or the other person has done or abstained from doing. does or abstains from doing, promises to do or promises to abstain from doing, such act or abstinence of promise is called as a consideration. Nowhere you find rupees, dollars, etc. Nowhere you have seen money consideration. Okay, see here, I will explain you the point. I am starting a coaching center in Hyderabad. Okay, one of you came to me and said, don't start coaching center in Hyderabad. I said, why you should not start? You said, don't start. If you don't start, I will pay you, okay, I will pay you non-compete fee to you. Means what? I promises to pay you non-compete fee if you don't start a coaching center in Hyderabad. My act of not doing something, you are paying me consideration. That's called as abstain. Abstain means stopping from doing something. That's why abstinence is also included. Okay, institute has given examples. Later you can read examples. I don't want to waste your time. Main concept discussion will be there. So consideration is an act of doing something, or consideration can be an act of abstaining from doing something. Okay, both the examples completed. Consideration must be at the desire of the promisor. It may move from promisee or any other person. That means either promisee can pay or his agents can pay. Sir, why any other person? If the promisee is a minor, guardian can pay. So any other person can also pay on his behalf. Next, legal rules regarding consideration. Consideration must move at the desire of the promisor. Okay, so let us see the point directly. See there, consideration must move at the desire of the promisor. That means how much consideration to pay, okay, will be decided always by the promisor. A case law is there, Durga Prasad versus Baldev. So what is that particular case law? Let me explain. There is a person called as Mr. D. Okay, there is a person called as Mr. P. D is the principal, P is a agent. Okay, D said, P, I will pay you consideration provided you sell these goods to the third party in the market. P sold to Mr. C. Okay, who decided the price? C said to P, I will pay you so much amount of rupees. P accepted the amount, and P after this went to Mr. D and said, pay me consideration. D denied to pay, and court also decided that D was not bound to pay, because how much should be the value of the contract, how much should be the consideration, should be decided by the promisor and not by any third party like C. C is a buyer. How buyer will decide the prices? So always it should be decided by whom? It should be decided by the main promisor. At the desire of the promisor, this consideration should go. Okay, sir, what is the link between my agency commission and the selling price? On the selling price only, certain percentage we will pay as commission. This selling price should be at my desire, not at the third party's desire. So it should move at the desire of the promisor, not at the desire of the third party. An act done at the desire of the third party is not a consideration. Okay, is not a consideration. Next, consideration may move from promisee or any other person. If you see in the definition, they said. Okay, so what is this particular concept? Let me explain this. So next one, consideration may move from a promisee or any other person. So what do you mean by this? The person who pays consideration may be a promisee or maybe some other person also. So what does this mean? Say for example, Chennaiya versus Ramaiah case, like everyone know that. Therefore, I don't want to again repeat the same thing and waste your time. I will give another good example. A, B, C, three parties are there. Okay. A sold goods to B. B has to pay consideration to A. B sold goods to C. C has to pay consideration to B. Okay. Say for example, consideration is of a equal amount. Let's say for example 1 lakh, 1 lakh. Now C was ordered by B. B said to C that, C, anyway you have to pay me na. You do one thing. You directly pay to Mr. A. What you need to pay? Consideration. So now try to understand. C cannot sue Mr. A for the contract of sale, but C can sue for consideration. That means a stranger can have rights on consideration, but a stranger cannot have rights on the contract. Say for example, A sold goods to B, yes. B sold goods to C, yes. Quality of the goods sold by A to B are not good. Quality of the goods sold by A to B are not good. Okay, on that issue, C cannot sue A because a stranger to a contract don't have any rights on the contract, but a stranger can have a rights on the consideration. So B said to C, C, you don't pay to me, directly pay that to Mr. A because anyway I have to pay. Now C is not the real promisor, some other person, he is paying A. This is also valid. That's what we mean. Okay, executed or executory consideration. Executed or executory means what? Executed means already done act. Executory means just a promise. Okay, see here, a consideration which consists of performance of an act is said to be executed. When performance is not yet done, only a promise is made, it is executory. On this only we have seen past, present and future. Has done, past. Okay, has done, past. It's a past consideration. I told you very clearly. So it can be past, it can be future, it can be present. Anything it can be. Consideration need not be adequate. Sir, what do you mean by this? What do you mean consideration need not be adequate? That means this particular article is worth 1 lakh. Consideration should also be 1 lakh. It need not be. It on the desire of the promisor. Therefore, try to understand clearly, something in return need not be equal to something given. Very, very important thing. It can be some value. It need not be exactly the same. Okay, that's the main point. Performance of what one is legally bound to perform. So what is this? See here. Performance of what one he is legally bound to perform. Sir, what is this? Certain things are there where as per law you have to do that. At that time you should not ask consideration. Example, witness will be there in a case. You have to come to the court. You have to give the witness. You have to say all the facts before the court and you need to leave. For that a person is asking consideration. You cannot ask consideration. Such contracts are absolutely void for want of consideration. Hence a promise to pay money to a witness is void because a witness is legally bound to perform the task. Next, consideration must be real and not illusory. Sir, what does it mean? Okay, what does it mean? Let us say for understanding. Okay, see here. Superficial things which are impossible to perform, called as a supervening impossibility, will be called as a illusory. Sir, what does it mean? A person said, I will sell goods to you. In consideration, what you will pay? Promise is said that I will bring a dead person alive back. Or you go there is a treasure inside the ground. You dig that, you will get a treasure. I will do magic. Like that, he is telling certain things which are attached to a supervening impossibility. Those cannot be consideration. Consideration must be absolute. It should not be illusory. Next. Consideration must not be unlawful, immoral or opposed by public policy. Sir, what does it mean? Okay, simply whenever you see the language, even in the definition, if you observe the definition given by the law, just a minute. See here, if you see this consideration, promise is the word used. What is that? Promise. Promise means what? Promise to do something which is valid as per law. Illegal promises are anyway not valid. Then on a illegal promise, how can you put a consideration as an attachment? Therefore, consideration must not be unlawful, immoral, etc. Okay, so what does it mean? So let's try to understand. Institute has given one example. ABC Limited promises to give job to Mr. X in a government bank against a payment of rupees 50,000 is what? That means one person said that bribery, technically, you pay me this much, I promise you to give a government job. Bribery itself is unlawful. Then how can you tell that it is a valid consideration? Bribery, all these things, money laundering, black money, all these things can never be considered as a consideration. Only presence of consideration is not sufficient. That consideration should be lawful. Anything which is immoral, opposed by public policy, cannot be considered as a valid consideration. So consideration is not important, valid consideration is important. Okay, so to sum up everything whatever we learned, consideration is an essential element to the contract. It is something in return, also called as a quid pro quo. Okay, first one, price agreed between the promisor and the promisee is called as a consideration. Valuable consideration will come out of the promisor's desire and will be paid by promisee or some other person. This is what we have seen. We can pay consideration for the act which is already done, or being done, or to be done in the future as a promise. Okay, act of doing something, it can be for abstinence. Okay, that abstinence only we call here as a forbearance, not doing something. Consideration must be at the desire of the promisor. It must move from a promisee or other person, present, past or future, or past, present or future. Desire of the promisor, and it may move from the promisee or some other person. I told you this example. Next, it may be future contract or already done, present or past or present or future consideration it can be, and it need not be exactly to the value. There must be consideration, it need not be equal consideration. Legally, if you are bound to perform certain things, for that you can't ask any consideration. It should not be illusory or which is a supervening impossibility, and it should not be unlawful, immoral or opposed by public policy. Okay, so I am not feeling well today. Just because of that fact, I couldn't record more than this. Definitely in the next session we will complete consideration, and I promise, this is a promise from my side, next session we will be completing once I was set well. Okay, I will be next clearing out the next concept, consideration, along with essential elements of the contract I will cover. And many of you are also requesting for third chapter of Sale of Goods Act. I will also cover that. Okay, so thank you very much. Please do prepare everything. Do the past examination questions on this area. Do the MCQs given below in the study material, and read 4-5 times the same answer. Definitely you will do well in the contract act as well. This 15-20 marks is our treasure. Okay, so thank you very much. Well done everyone.